Good morning, everyone. I'm Diane Cohen with MacroPro, and I'm joined with Mandy Farquhar. Hi, Mandy. How are you this morning?
Great. Hi, Diane.
Are you all ready for the holidays?
I'm as ready as can be.
Oh,
At this point, I'm just going to move forward with what I have.
yeah. It does become very busy. We have an active crowd this morning already sending us messages. Good morning to everybody. So one of the things that I do every year is I put together a trivia question or trivia sheet for my guest, and we do the questions and we have little prizes and things like that. So I thought this morning I would ask a few questions of you and to our audience. It looks like this, and you'll see that there are questions on both sides. So if you would like a copy of this to do with your guest, please text me and let me know, and I will be happy to email that over to you. So make sure you say yes and send me your email, and I will do that. And it would be best if you actually sent it to my email address at Diane, DIANN, @macropro.com, and then I'll send you a copy. So here we go, Mandy. Let's get started here with the question. In what city did the Nutcracker premiere? Was it in Vienna, Austria, in St. Petersburg, Russia, or in Berlin, Germany? Let's see if anybody else guesses on it. So let's see if any of our guests get that.
Tell me when you want
we do got guesses. Yeah. We do have a Russia, a Vienna, we have a Austria, a St. Petersburg, a Berlin, another Austria. So people are guessing. What's your guess, Mandy?
I say Russia.
It is Russia, absolutely. And this year, Hanukkah, yes, good job. This year, Hanukkah actually falls on Christmas Day, which is a phenomenon that only happens about every 15 to 16 years. And my husband being Jewish, I thought that I would include a question on our thing this year. So it says, one of the best parts of the Jewish holiday is the food. To celebrate the miracle of the oil, which is what Hanukkah is the miracle of the oil, they have fried potato cakes. What are those called?
Oh, it starts with an L, Laskas or something like that, isn't it?
It's something like that. Let's see if anybody gets it. Let's see if anybody else gets it. Oh, Tana got it, and Marsha got it. Christine, you were close. Gina Green she got it. It's called latkes. And so those are just a couple of questions that's on the quiz. If you guys would like to have a copy of that, I'd be happy to share that with you. It makes our holidays just, gives us something to talk about around the dinner. And like I said, we just give little prizes for some of the games that we do. All right, Mandy, I am going to do some housekeeping, and then we're going to bring on our guest. Yay. All right, so today our webinar is worth 1 CEU. You should receive your credit in roughly about 1 hour. If you don't receive it, you need to let me know pretty much ASAP. I can only help you out for the first 30 days. You do need to be logged on to the GoToWebinar process, so you use the link that they sent you in order for you to get your CEU hours. There are handouts for today's presentation, so please make sure you download those so you have them. If you have any questions, Tim is going to take those questions. As soon as we see them, we'll be asking him those questions. So feel free to ask those questions, and then this will be on a replay on the MacroPro YouTube channel, so you can always watch it there. All right, Tim, why don't we have Tim come up?
I am here. Good morning, everybody.
Hi, good morning.
Tim, did you get any of the answers right?
I knew latkes because I make those for Christmas.
You make them for Christmas?
Yeah.
Nice.
Yeah. The other one I did not.
Ah, very good. So, well, excellent. So are your Christmas plans all done and ready to go?
As best as they could. They kind of got derailed last week a little bit, but we're back on track.
Excellent, excellent. So Tim, can you tell us a little about you and your firm?
Sure. My name is Tim Rose. I'm an equity partner of Siegel Moreno and Stetler. This was, I believe, my third time presenting for MacroPro, so I really appreciate the opportunity. I run our Northern California operations, Sacramento and the San Francisco satellite office, but I also handle statewide for a couple of dedicated clients. So I am Northern California some days, Southern California the others. Our firm in general, we have offices in San Diego, Orange County, Inland Empire, and Los Angeles as well, and full service workers' comp and subrogation.
Excellent. Well, Mandy and I are going to get off screen. We're going to leave it to you. Again, if you have questions for Tim, please put them in the box. And I want to say congratulations to all the people who got the questions correct.
All right. Okay, everybody, I'm going to be showing my screen. Hopefully everybody can see it. Diane, if there's a problem with the screen, please let me know as soon as possible. First and foremost, there's a little bit of information here from MacroPro for the CEUs of Christmas. This presentation will be made available to everybody, but there is 1 hour of continuing education for this webinar, and the instructions on how to provide or get that information is listed right here. So we're going to be talking about good faith personnel actions. I know there's nothing that'll get you into the holiday spirit more than personnel actions, psychiatric claims, things of that nature. That we were saying off the webinar before that this is kind of a stressful time of year, so I guess there is some application. Just a little bit of background. We're going to be talking about the ROLDA analysis. We're going to go through just a little bit of a background on the psychiatric claim in general, kind of what are some of the things that are needed in order to plead one. And then we're going to talk about the ROLDA case, which is kind of the bellwether case with regards to personnel actions. And then we're going to talk a little bit about what employers can do to actually help themselves, help us when it comes to defense of, I believe, a very important defense as it pertains to potentially barring a psychiatric claim in its entirety. A couple of things on how this all started. One of my clients that I am dedicated counsel for has a nature of a business that is large turnover based. It's very fast paced. There's a lot of merging of departments. And as such, we were running into a problem with when people would file psychiatric claims and it would be related to a personnel action. There was some documentation problems. There were some problems with supervisors not providing information, trying to figure out exactly who knows what and who we should speak with. And it kind of led to me wanting to provide some education to this employer about how to better fix the way that they run their human resources department as it pertains to documentation. That started out with a very limited conversation. It expanded to some other individuals, and then it eventually went to their entire supervisory department, and then it went over to the management department. And before I knew it, we were kind of expanding on this, and I was teaching them all about the ROLDA case and how personnel actions work. So we decided to put it together in a presentation that could be made available for everyone. And the great thing about this is there is something for everyone. Whether you are a claims examiner or an employer, an insurance carrier, there is something that everybody can do to help with this defense. So we're going to start off by talking about psychiatric claims in general. Now, in the workers' compensation world, basically, if you have a 1% contribution to an injury, you own it. So orthopedically, neurologically, things of that nature, but psychiatric's a little bit different. Because the actual events of employment must be the predominant cause, meaning 50% or greater, or 50.1%. However, if there is a violent act, the standard is lowered to 35 to 40% of the psychiatric cause being work-related. So the most common thing that I could think of as an example was you're a bank teller, somebody comes in and sticks a gun in your face and holds you up. That would be the example of a violent act, and obviously the threshold would be a little bit lower. Now, employees must be employed for 6 months, though it need not be continuous. That's actually a pretty common question I get. You'll have somebody that works for a few months, then they are on a leave of absence or something else, or they come back. and then they work for a few months more, but the total itself is greater than 6 months. It does not need to be continuous. So one of the other things that I commonly run into is if a claim is filed after notification of a termination or layoff, there are certain exceptions that must apply to be compensable. We will have individuals that will be either notified, say their department is closing, or there is a 2-week layoff notice or something to that effect. And then during the time in which they are still working but are going to eventually be let go, then there is some sort of event that triggers a workers' compensation claim. Some of the exceptions is sudden and extraordinary events of employment are a cause. That means something that was not expected. It's pretty much as it says, sudden and extraordinary. There is some case law on what exactly that term is and when it's defined. Don't need to go into it today, but any attorney that is handling a claim will need to understand what exactly does that term mean. The employer has notice of the injury prior to the termination. It's possible that they sustained an injury before they were notified that they were being let go, and they have some documentation to prove that, such as medical records that demonstrate the treatment that they received prior to the notice of termination or layoff. This is really important for the psychiatric component. I have found that a lot of psychiatric injuries don't start with the reporting of an injury. It starts with the applicant seeking out medical care through a private care physician, or there's mention of stress. Work issues are mentioned in the medical record. Maybe they're being treated for something else, and then their doctor makes a referral for some sort of psychiatric treatment. But long story short, there's evidence, if you will, of some sort of problem before they're let go. If there's a finding of sexual or racial harassment by a trier of fact, that's pretty much a self-explanatory. We want to make sure that we're free from sexual harassment or racial discrimination in the job force, and the legislature has opined that it really doesn't matter when that occurred, as long as it did occur and can be established. That's an exception to the basic threshold compensable consequence injuries that we sometimes see in psychiatric claims. And then finally, evidence that the date of injury under the labor code, either 5411 or 5412, is subsequent to the notice of termination, but prior to its effective date, again, during that 2-week, 3-week, whatever period of time window. Now, there's a couple of causes of a psychiatric injury. The first one is a specific injury. I mentioned a bank teller being held up at gunpoint. That's one incident that occurred right then and there. And so that's a specific incident. Another one that we see that's pretty commonplace is some form of an assault at work. Sometimes individuals will get into fights, things of that nature. And then you have a cumulative trauma injury, which is exposure to working conditions. Cumulative trauma injury is an injury that occurs over time. Think of the straw that broke the camel's back. And the most common thing that I've seen, which is a good example, is repeated harassment or some sort of abusive work environment. Now, of course, is it an abusive work environment? Is it reasonable? Those are all things that we take into consideration. But assuming that it is found that there is some sort of workplace abuse or harassment that occurs over time, that could create the cumulative injury. And then that would be a pure psychiatric injury in and of itself, because the third one is a compensable consequence from an underlying injury. So for example, you have somebody that sustains an orthopedic injury, and as a result of that orthopedic injury, they begin to experience problems with anxiety, depression, things of that nature, concerns about finances, their future, so forth and so on. And so therefore you have a psychiatric claim that manifests itself over time. So the big case that every attorney and examiner should know about is the ROLDA decision. Before the ROLDA decision came out in 2001, there was some question as to how exactly do we address personnel actions. There really wasn't a set roadmap, if you will. It was kind of one opinion from one judge differed from an opinion from another judge. And so finally, somebody came up with an analysis that has since been adopted. And in my opinion, it makes a lot of sense. There are some cases that have come out since the rolled decision that kind of clarify a few things, as case law frequently does. But Rolda versus Pitney Bowes started it all. And in that case, it involved a salesperson who was assigned new duties in addition to being a salesperson. And as a result of that, he had some questions about how his job would run and how it would operate. And he sought out guidance from his management staff as to what these new duties were, how much time they were going to take up, what were some of the requirements, how does he address certain things. And truth be told, there wasn't a lot of explanation given to him, and the new duties were not really explained in adequate detail in writing. So as a result, he had started to experience problems with work. He was disciplined for his job performance. He had a couple of performance action plans, some write-ups, and ultimately he filed a stress and psychiatric claim. And as a result of that, they went to a med-legal evaluator who found some uh, psychiatric injury and did not really provide a great explanation as to how was it related to work, was it personnel action related, so forth and so on. And so after the case was tried and it went up on recon, they eventually provided some greater explanation, and we have the four-step analysis. Just as kind of a side note, there was another case that came out this year. It's the Cisneros versus Los Angeles Unified School District. It's a 2024 case. That actually provides a good assessment as well. And it kind of serves as a refresher, if you will, for how the ROLDA analysis works and how we would apply a good faith personnel defense. So that's something for anybody to take a look at. And I can provide that information as well if you reach out to me. So the first step analysis is actual events of employment are involved. A judge determines. Now, that may seem like kind of an obvious thing, but there are a lot of instances in which we will delve into somebody's history and their work and their life, and we find out that there's a lot of things that they believe are related to work or that might actually be related to work that in truth are not. But most of the time, it's pretty straightforward as to whether or not there is an actual event that occurs at work that is involved, and the judge will make that determination. That is something for the applicant to demonstrate. We then have an injury must be predominantly caused. So the psychiatric injury in general must be greater than 50%. By employment, that is determined through the medical record. You will have a medical evaluator give an assessment and ultimately determine that they think that more than 50% of all the issues that the applicant is experiencing are due to something that has occurred at work. The applicant must prove this. Truth be told, it's not really a tremendous burden for them to prove it. I will kind of talk about that a little bit later. But once they do that, then we go into the third stage, which is whether or not the actual events of employment are personnel actions, number one, and if they're lawful, non-discriminatory, and in good faith. We're going to talk about the Larch decision in a couple of minutes, but in that decision, it provides kind of a good assessment where it has to be lacking outrageous conduct. They have to be honest with a sincere purpose, the personnel actions do, and then they have to be without collusion or unlawful design. Now that's kind of a lot of fancy words, but long story short, they have to be done in good faith, they have to be reasonable, and they have to be done with no ulterior motive in mind. And a judge will ultimately determine whether or not those are actual personnel actions and if they're lawful and non-discriminatory. And then the final step is whether or not they are a substantial cause of the psychiatric injury, and the threshold is 35 to 40%. A doctor will make that determination, so we need to make sure that the medical records first of all determine whether or not there is the 50% threshold met for the general psychiatric, and then the 35 to 40% for the personnel actions being part of that total. Now, on its face, you might think that 35 to 40% is a fair percentage, but it's not incredibly difficult. I have found that it actually can be quite difficult for a number of reasons, and we're going to talk about that in a couple of minutes. So how do we go through this? The parties go through an evaluation. It could be the treating physician, could be the QME. Most of the time, if we're going to be asserting a good faith personnel defense, we're going to have a medical legal evaluation. There's already going to be a primary treating physician that has found industrial causation. They might have done an assessment of ROLDA, usually not. We then go to a med legal analysis, and they will conduct an evaluation and hopefully answer all those questions. The matter is then heard at the appeals board. If we fail to address the substantial cause threshold, we're going to fail in terms of a defense unless there's some other defense that might apply. So we have to make sure that all 4 of those steps are adhered to, that the medical is solid, and that we can meet our threshold for that personnel action defense to apply. Now, actual events of employment are different than personnel actions. And because they're different, they have to be addressed separately. Now,
Tim, I have a question here
sure.
from Jennifer. What was the name of the 2024 decision revisiting the ROLDA decision again?
It is Cisneros versus Los Angeles Unified. And at the very end of this presentation, I will have my contact information. And so if anybody has any questions regarding case law or anything else, again, you can actually reach out to me directly and I can provide links. So for example, I can provide you a link with that case. So what exactly is predominant cause? Now, I've never met a person in my life that does not have some sort of stressor outside of work. Some people may never go speak with a psychologist or a psychiatrist or a counselor of any kind. That does not mean that they're without stress in life. We all have it. There are stressors outside of work and at work that sometimes make people predisposed to having problems associated with work. We all have different personalities. Some people are type A's, some people are type B's, some people have a history in their life of problems, some people don't. But there are stressors in everybody's life. They could be active or they could be inactive. I put down a couple as examples, but I could probably spend an hour writing a list of everything that could potentially be identified as a stressor. You know, abuse as a child or an adult. You could be in abusive relationships. You could have a divorce. You could have family issues. You could have issues with friends. You could be in disputes with both of those. There could be deaths in the family that somebody would take really hard. There may also be disorders involving food, weight, sexuality, or other mental issues. When we depose somebody and they have pled a psychiatric injury, I always let them know from the very beginning that I'm permitted to delve into some very delicate areas of their life that you may not want to talk about with basically a complete stranger. Because a psychiatric injury has been pled, I'm permitted to go into those things, and I will always approach them from I would like to say a kind or compassionate position, but I am going to be probing people about some very personal things. And I have heard over the course of 16 years as an attorney that some very intimate details that I'm sure people really wouldn't want others to know about. And it is because of the nature of the psychiatric claim that I am permitted to ask about those type of things. We have other work factors which can cause psychiatric stressors. The most common one that I see is workload, power dynamics between supervisor and employee. As a business owner, I completely understand that. Sometimes there is a little bit of a power dynamic between supervisor and subordinate, and then also cultural factors. We do live in a world where everybody has different cultures and beliefs, religious preferences, non-religious preferences. All of those things could ultimately contribute to workplace stress or non-industrial stress, which then goes to the heart of whether or not we have met the appropriate thresholds for establishing predominant cause. Now, I mentioned earlier that it's somewhat, I would say somewhat easy to get to the 50% predominant threshold that must be proven by the applicant. The Labor Code 3208.3 specifically states that they have a preponderance of evidence to prove predominant as to all causes combined of the psychiatric injury. Now, when I depose somebody, I want them to tell me everything. I want to hear about all their claims of harassment, anything of prejudice, wrongful termination, discipline, actions, problems that they have with coworkers, supervisors, things of that. They are going to lay it all out for the primary treating physician that's going to be on this case, as well as the med-legal, and I want them to tell me about that as well, which for reasons that I will explain in a minute. The medical legal evaluator or the other physician would evaluate and need to find that 50% threshold. If they do, then the applicant has met their burden as to that first element in order to address a good faith personnel defense. The reason why I say it's easy is because a lot of treating physicians that evaluate the applicant are doing it at the request of applicant's counsel. Psychiatric claims are denied more often than others. There are also doctors that know that they want to treat a psychiatric injury. And so I have seen many reports over the years where the doctor will kind of do a cursory history. They will kind of delve into the background, but not really. They will take the applicant at their word at face value, and they will spit out an initial report that basically says, after reviewing my assessment and my assessment notes and completing an evaluation, I believe that there's this 50% threshold, and therefore it's an industrial injury, and now I want to provide a bunch of medical treatment. I cannot tell you how many times that I have then deposed somebody and found a significantly different history than what was reported to the primary treating physician. And I have had a lot of experience in which the primary treating physician will not go back and kind of reassess. They'll simply say, well, you know, there might have been a mistake here, or they might have omitted that there, but that doesn't change my original position. I still want to provide this medical treatment. Now we have a medical report and potential medical history that another doctor is going to be relying upon. And it kind of creates that uphill battle for the defendants in addressing whether or not the reporting that they're relying upon when we get to that med-legal evaluation is substantial medical evidence. That's a whole other fight that we often will have to have. Now, the 35–40% threshold is not as easy as it looks. When I first started really taking cases to trial to argue a good faith personnel defense, I quickly realized that physicians do not like this argument. I don't know if it's because they feel they have a personal investment because the individual is either a patient or they're being evaluated in the med-legal process. I believe that med-legal evaluators by and large want to find industrial injury, and psychiatric or psychological is absolutely no different. And so therefore, there's a lot of things that they do to, I would argue, prevent the defendant from being able to assert this defense. A lot of things are rationalized. I say that they're explained away. Events, comments, positions of parties. The most common one that I've seen as of late is they try to differentiate between what the actual event was or the personnel action was versus the perception of the applicant to that event or to the working condition in general. And then they say because one is an actual event or an actual personnel action, I'm going to assign a percentage, but because the person feels this way, I'm not going to assign that towards whether or not you can get to that 35 to 40% threshold. And the question that I've asked quite a few QMEs is, why would you differentiate between those two? If there is a huge emphasis that this person is making about this particular action or this particular set of actions, why would you then try to separate them? Because in my opinion, they should be combined. And that would help us get to the 35 to 40% threshold. The other thing that I see is that they actually try to say something that is a personnel action isn't. They make a legal determination, which they're not permitted to do. They try to lump events together by taking the most serious ones perhaps out, and then everything else is just kind of put together in this one lump category, and then they assign just a very small percentage to it. They might give greater weight to something that's larger, like a serious suspension, a termination, something to that effect. But by lumping things together and assigning a smaller percentage, it becomes more difficult to get to that 35 to 40% threshold. I've also had some doctors that don't find a percentage on any action at all. They will say that although the person talked about it, although the person said that they were bothered by it, although there was a write-up, although they talk about it at their deposition, although they explained it to me, I'm not going to assign any percentage, but they don't really provide an explanation as to why. The next most common thing that I've seen is explaining away contradictory statements or positions of the applicant. The most common thing that I see in a medical report from a QME is when there's a contradictory statement that is clearly contradictory to what they testified to or what they explained to another doctor, is that it's a cry for help. Could that be true? I suppose. But when you have an applicant that is mentioning something to a med legal evaluator and to a primary treating physician that is clearly contradicted by other medical records or by their deposition testimony, it does bring up a question as to credibility. But I have had plenty of med legal evaluators really kind of discount that and not really give it the weight I think it deserves by just basically saying, well, this person is crying for help, we need to provide them with medical treatment. So, what is a personnel action? I put a list of certain things. It could be transfers, demotions, layoffs, performance issues, suspensions, evaluations. Some of these are very subjective. They are up to the judge to determine. The general term that we would use is conduct either by or attributable to management completed by someone who has the authority to review, criticize, demote, or discipline an employee. That actually comes out of the large decision. Disciplinary actions that are short of termination may be considered, even if they're harsh, as long as they're not clearly out of proportion to the employee's deficiencies. So what that means is if you have a management decision that is pretty harsh for what you would normally perceive to be the type of discipline that you would see for someone who's committed this infraction, as long as it's not beyond the realm of reasonableness, it can be harsh. Now, this disciplinary action definition is not meant to cover all actions by any level of personnel. It's just kind of a guidepost for us. In the Larch decision, she was a deputy sheriff and she had some criticism by a non-supervisor that management actually adopted and kind of added to the disciplinary process. They basically said this individual that had criticized her, yes, we agree with this assessment and we are adopting it and it's going to go into this personnel action. And the doctor originally tried to claim that, well, it wasn't a supervisor and so therefore it can't be considered. And upon reconsideration, the court said, no, you definitely can. A personnel action does not have to result in termination. It doesn't have to result in suspension or loss of pay or any other specific penalty. It can be a simple conversation. It can be a write-up. It can be a performance action plan. It can be any of those things. But it also, of course, could include termination, pay issues, suspension, things of that nature. The initial step could be criticism or action authorized by management. But again, it could always start with just a simple conversation that expands into something else. So the next question we have to ask is whether or not this personnel action is lawful, non-discriminatory, and in good faith. The Golick case was an interesting one because it really kind of tested the limits as to what was good faith. Mr. Gollett was a supervisor 2, that's a second level. Oh, did you have a question? You're on mute.
Mandy, you're on mute.
Sorry.
Go
Here
ahead.
I go. This is a question from Blanca. Would other employees' foul language amongst themselves causing the applicant to file a stress injury be considered a good faith personnel issue? There was no employer offense.
If we're just talking about somebody else using foul language which resulted in stress, I would probably say no. Obviously, the facts, we would have to kind of flesh those out a little bit. But if it's another employee that is offended by the actions of another employee and they're not really related to any type of supervisory activity, it's more along the lines of I'm offended by this activity, then chances are that would probably not be deemed a personnel action. Now, whether or not there was any type of response to that and whether or not there was any type of discipline meted out to the offended individual, that could in fact be a personnel action in and of itself, but whether or not it's good faith would then be subject to the court's interpretation. But I would say, generally speaking, if we're looking at it from a bird's eye view of employees not getting along with each other or one being offended by another, that in and of itself is probably not going to be deemed a personnel action. So in the Golick case, the applicant was a long-term employee for the city of Oakland. He was a supervisor 2. There was then a budget issue that surfaced, and it was determined that supervisory positions might be eliminated. And the applicant's direct supervisor had told him that there's a good chance your position's going to be eliminated. We might want to try to move you to another position. And so he had talked about creating a management assistant position and actually provided the applicant with some job functions and some other things to create this management assistant program. And he had talked about how the budget should be enough to afford him to move into this position. They were going to try to keep his same rate of pay. They were going to try to keep him as much as they could in the same department. And so the applicant, in good faith, relying upon this supervisor, had talked or had started in, down this new road. Well, as it turns out, that position never actually materialized, and the supervisor was somewhat mistaken in what the budget would ultimately present itself to be. And so the applicant was then demoted to a supervisor 1 position, and his job duties completely changed, and he turned around and he filed a psychiatric claim. And what they told him, what this case basically said was, although on its surface, it kind of seems like that might have been a bad faith move by the supervisor really was trying to act in the applicant's best interests, and he was mistaken himself. It was not something that was discriminatory. He wasn't doing it to deceive the person. He simply was mistaken in what the ultimate budget and management decisions above him would be. And so therefore, they determined that that was not outrageous conduct and that the supervisor himself was acting in good faith because of what he reasonably believed at the time. And when you were looking at it from the outside in, they ultimately determined that an outside observer would find this conduct to be reasonable. So how does documentation help us? Well, if I'm going to be having a med legal evaluator provide an assessment, I'm going to be sending him medical and non-medical evidence, which includes the personnel file. which includes anything that has to deal with the write-ups, suspensions, disciplinary actions, things of that nature. As I mentioned early on, the initial evaluators are probably not going to have this information, and yet they're going to make a determination on compensability with incomplete information. Doctors don't often like going against their fellow colleagues, and so they'll give great weight to those reports even if they're flawed. The applicant is going to be given the opportunity to take kind of the first bite of the apple. They are, I've found that they embellish things quite frequently. I have found that quite a few individuals are actually dishonest when it comes to the doctors. Some of the other evidence that we're going to later on send is, for example, the deposition of the applicant, the personnel file. But again, by the time we get around to these things, the applicant has usually been evaluated by somebody. They've usually provided their side of the story. And then we have to send all this information to the QME and ask them quite a few questions where they're going to have the applicant sitting in front of them, potentially refuting some of these things or trying to explain them away. And so therefore, it's important that we have as much documentation as possible. And I've mentioned everything from termination emails, notes, logs. We're going to be sending it all to avoid any claim of bias or cherry picking. We are going to show as much raw data as we possibly can to that med-legal evaluator. We're also going to try to send the medical history. That's where we get into whether or not the person's received prior psychiatric care. We're going to try to get those records as efficiently as possible. One of the other problems we run into are that applicant attorneys will schedule an evaluation pretty quick without us having a chance to even depose the applicant or gather all that information. So I usually will indicate that I am objecting to an evaluation to go forward until we've had an opportunity to conduct at least some reasonable discovery. And if they proceed, I have on instances told the QME, until we get this discovery, we're not going to pay for this evaluation. I'll file for a hearing. I'll get down in front of the court. I'll explain the delays on the applicant side. But I will make it very clear that we do not want to move forward until the QME has all of that information that they're going to need to make a reasoned decision. Again, we're going to be sending medical and non-medical subpoenaed records, potential civil or criminal information, and employer or witness statements. All of this will be turned over to the applicant's attorney beforehand, and we might have to litigate whether or not some of that actually goes to the QME. Personnel actions have to be well documented. If they aren't, then we fail. Documents, write-ups, disciplinary documents, we want to make sure that it's showed to the applicant, they're given a chance to explain, they're given a chance to sign, and we want to make sure that each incident is clearly documented. Was there a question?
One more question from
Sure.
Penny. Can DIO investigations be provided?
Certain investigations are usually provided. It depends on the nature of what the content is. However, if there are certain content within those investigations, the applicant side does have a right to question them. So they may actually have a deposition set up of an individual where there is a statement taken. They may have an opportunity to send interrogatories. They will be given a fair chance to try to gather some further information from those investigative materials, which could cause a delay, but again, they have a right to question the credibility or legitimacy of those investigation reports. So long story short, most likely yes, but the other side may be given an opportunity to critique or question the content, and we may have to have a hearing or even a trial over that issue. So getting back to documentation, we want to make sure that we include everything from email threads, which is why I've told employers sometimes keep your personal opinions out of it. Just document the material without any position of bias. You know, you want to avoid profanity. You want to avoid calling the people, you know, calling the person an idiot, things of that nature. And we'll talk about that in a minute. And again, in order to assert this defense, we have to meet that threshold. So I came up with 7 rules as to what the employer needs to do. And the great thing about this is the more the employer knows ahead of time, the more they can start to implement this with their human resources and with their supervisors, and the easier it'll make the process, because good documentation is important. And truth be told, a lot of this will be done before we even have a workers' compensation claim filed. Number one, we want to describe company expectations. We want to clearly state what the job description or the company policies require. For example, you don't want to say, be at work by 8 o'clock. What does that mean? Does that mean I'm pulling into the parking lot? Does that mean I'm getting my first cup of coffee at 8 o'clock? I'm punching in, or do I need to be at my desk ready to go? We want to be very specific in what the policies require and what the job description calls for, because in those gray areas is where you have this confusion. They told me I had to be here at 8, but they didn't specify what it is, and so therefore I don't understand why I'm being written up when I was clearly on site at 8 o'clock in the morning. We want to describe behavior or performance that must change. I always say avoid using absolutes such as always or never unless it is appropriate to do so. We want to make sure that we give the employee an opportunity to explain why the expectations aren't being met. Sometimes it's just a matter of communication. Sometimes they feel like they're being targeted. Whether or not that's true or not, we want them to be given an opportunity to explain their side, because sometimes we can go through a corrective action with their input that'll make it better for them and for everybody else. And sometimes they're right. Sometimes some of the things that some employees may come down on them pretty hard for are either not explained or are incorrect, or there's some other issue. So it's important to give the employee an opportunity to kind of explain themselves and explain why there is this issue. Next is to prepare a detailed plan of action to improve the performance. I really like it when employers come up with an action plan with set guidelines and set deadlines. So that way everybody's on the same page. The applicant understands what their expectations are, or I should say employee understands what their expectations are, and the employer has a responsibility as well, and they're kept on the straight and narrow as well. We can then have follow-up, good communication. There can be modifications if needed. If there's continued problems, there can be further discipline meted out, things of that nature. But it's always a good opportunity to coach an employee, to give them those tools so that they can be successful. We want, again, as I mentioned, kind of set specific deadlines for correcting the behavior, but it's important to keep it in writing. This is where that documentation becomes really important. I want an applicant to tell me every single grievance they have with the employer, whether it's 1 or 50. I will spend all day in a deposition with them if necessary in order to gather that information, because each one of those things potentially is a separate personnel action, and each one of those things potentially has a percentage attached to it to get me to that good faith personnel defense threshold. So I want them to tell me exactly what the problem is, and I want the employer to demonstrate that they have had this issue multiple times over the years, or they've had 10 different instances of problems. Here's all of them that are well documented, and that way when I depose the applicant and potentially depose a QME later on, I can go through that list and I can ask them specific questions and really kind of dig down deep as to what the real problems that the applicant has, and what are the things that the employer noted that were subject to some sort of personnel action. We then want to be as detailed as possible. Again, the more detail, the better, because that allows me to better analyze whether or not we have a defense, whether or not we should be looking at litigation, settlement, things of that nature. Next is to describe the consequences of the behavior if the poor performance continues. It could be a simple, first time is a verbal, next is a written, next is suspension, next is termination. Most employers have some sort of general guidelines, but we want to make sure that they're clearly identified so that, again, it's approached from a fair and unbiased perspective, and the applicant or employee is clearly aware of what will happen if the behavior doesn't improve. And when it comes time to a corrective action, we want to make sure that we are stating specific dates, timelines, deadlines, things of that nature. And we want to make sure that there's always a follow-up with every communication. Next, we want to make sure that we avoid vague phrases. We also want to make sure that if you have some sort of a feedback section or a workday profile, I put that down there in bold for just general reference. I don't know what each employer is going to call it, but most of the time I've seen it as a feedback section or a workday profile, anytime coaching, things of that nature. We want to make sure that all of those things are well documented, they're contained in the personnel file, and they can be made available to anybody that requests them. Now I put in a little bit about 132A. I won't go in incredible detail. I know there's a lot of information on this page, but 132As are claims that are filed in the comp arena, but they're usually addressed after the case in chief. I always try to include them as part of some form of settlement. Most of the 132As that I see are filed kind of as a secondary to the workers' compensation claim. They're usually based on little to no research. They're just some general allegations. As a favor to the employer, I will usually issue some form of a generalized response saying that the allegations are denied. Most of the time, 132As are not covered under standard workers' comp insurance, and so therefore the employer would potentially have to seek out separate representation. And of course, I always try to include them if we settle a claim, but I will also ask questions that will potentially help the employer later on, because it's usually tied into some way with the psychiatric claim or even an orthopedic claim or a neurological claim. Sometimes those 132A allegations really kind of dovetail nicely into the case in chief. And so when I'm speaking to the employer before I depose somebody, I'm always going to be asking them questions and want to get some more information to find out how I can be of benefit to them when I'm deposing the applicant, because that evidence is potentially discoverable with a 132A action. But it's important that employers are not retaliatory. They keep emotion out of it. They well document performance issues. They make sure that they apply their policies consistently. That means it's applied to everybody unless there's some form of an exception. That they keep an established timeline of events, and that if there's any witnesses to an incident or a problem or a personnel action or something like that, that we know who those individuals are and we're able to speak with them and be able to gather as much information from them. Written statements are always good in case the person leaves the employer, but it's always important to try to get that information from them. Now, this is my contact information. I have a very understanding spouse who will allow me to take calls after hours. I answer a lot of emails for individuals, and when I don't have cases with them at all, I'm happy to do that. Now, I will say in closing, kind of going back to the beginning, since we implemented some of these changes to human resources for my dedicated employer, we have had a total of 4 psychiatric claims in which we've asserted a good faith personnel defense. The first one, with the change of documentation, we went to trial and we got to take nothing. The second and the third ones, it was enough information and enough good quality information provided at a deposition to force the applicant to a much more reasonable settlement than what we really anticipated. And we also expect that when we go to trial on the fourth one, which will go to trial, we've already kind of established that, I feel pretty confident that we'll be able to prevail on that as well. So the proof is in the pudding, at least for this direct employer. And I think that if these recommendations are applied with any employer, there can be a good and successful outcome. That's it. Thank you very much.
I have one more question.
Sure.
This one's from Keisha. In the settlement documents or legal correspondence, should defense attorneys indicate monies are paid directly from the ER, as this may not be indemnified by the employer?
Could you repeat that again? I want to make sure I heard that correctly.
In the settlement documents or legal correspondence, should defense attorneys indicate monies are paid directly from the ER, as this may not be indemnified by the employer?
Well, I guess it would depend on if the employer is contributing. I think if you're talking about a 132A where there is a
Yes.
separate payment, okay, then yeah, usually what I will indicate in there is who contributes what. And it would be the same as if it was a co-defendant. So I settled a case with the 132A where the employer wanted to kick in a couple $1,000s, and we were able to resolve it with the 132A thrown in. And what I indicated was the employer will contribute X amount, and then the case in chief is payable by the defendant for Y amount. But I did specify that it is a separate and distinct payment in order for everybody to be aware of who was paying what. And then as far as putting it on the order, I also wrote in a separate little assessment as to who pays what. And I also included in the settlement documents that this resolves the 132A, all claims for it for full and final satisfaction. The employer maybe still disputes, but they wanted to buy their piece. So I make sure we're very specific in that language.
Tim, I want to thank you so much for being our guest today. And Mandy, I want to thank you for helping set this up and being my co-host today. We have one more webinar of the 12 CEUs of Christmas, and that will be this afternoon at 1:30. James Rossi and I will be speaking on unlocking successful apportionment. So we hope that you will join us. Please do. I mean, it's the last one, so we would really appreciate your support as you have shown here today for Tim. All right, everybody, thank you so much. And for those of you who had asked about the handouts, they are attached to the control console. They are under handouts, so please download those now so that you have that. And then someone else mentioned that they lost audio. And so unfortunately, everything is working on our end, on GoToWebinar's end, so it is on your end. But if you can hear me now, you can watch this again on the YouTube, on the Macro Pro YouTube channel, and then you'll be able to hear everything that Tim had to say. And all of you who have asked for a copy of the little trivia game, they have been already sent to you, so you will have them to enjoy for the holidays. All right, until this afternoon, I will see you then. Bye-bye, everybody, and happy holidays. Bye-bye.
Thank you.
Thanks, Tim. You did a great job as always.
Thank you. Appreciate it.